Hello, and welcome to this episode of the Maryland Risk Management Education Podcast. My name is Paul Geringer, and I'm the Extension Legal Specialist here in the Department of Ag and Resource Economics at the University of Maryland. And today we're going to continue on with some discussion that we've done before in the past on hemp and some of the rule changes that we can potentially see as we see more and more producers growing hemp and as it becomes legal with USDA releasing regs later this year in 2019. To tell us, how this process is going to move forward with the changes in the 2018 Farm Bill. But today I want to focus in on a different issue that may come up, and it's already come up here in Maryland a couple of times, is looking at how do right-to-farm laws apply in the case of hemp growers. So the 2018 Farm Bill allows for growers to grow industrial hemp. A farmer looking to add industrial hemp on fields creates a possibility of conflicts between neighboring landowners. The neighbors may not understand that industrial hemp is now legal to grow or have other concerns. Industrial hemp is now a legal commodity, and growers would potentially fall under Maryland's right to farm law. Industrial hemp would also be eligible for the nuisance defense in the right to farm law. So let's talk about right to farm laws generally. So right to farm laws provide a qualifying agricultural operation, a defense in a nuisance action brought by a neighbor. To fall under the right to farm law, the farm must have been in operation for at least 1 year. This requirement does not mean growing hemp for 1 year, but the farm needs to have been established for at least 1 year before claiming the defense. For those growers that are just starting a farm and growing hemp for the first time, you would need to be in operation for 1 year before the defense applies. For other farms that have been established for longer than 1 year, switching crops should not impact the ability to claim the right to farm law nuisance defense. Maryland also requires that the agricultural operation comply with existing federal, state, and local laws and regulations, and that the operation not be conducted negligently. The operation must be an agricultural operation involved in either on-farm production, harvesting, or marketing of an agricultural product grown, raised, or cultivated by the grower, or be involved in the processing of an agricultural product. The law does not define an agricultural product in Maryland's right to farm law, and the Maryland Court of Appeals has not ever addressed this issue. When interpreting this word for the first time, agricultural product, a Maryland court would begin with the ordinary, everyday meaning of the language in the statute, and this is based on prior case law. Definitions found online typically define agricultural product broadly to include most products grown on a farm for commercial purposes, and this is sort of where a court would begin its analysis if it was looking at this issue. Hemp seems to fit comfortably within this broad definition, but we really don't have a court to answer this question yet, so we're just kind of guessing that it would be. But the guess is it probably would fall under the right to farm law. So what about hemp and right to farm laws? Assuming hemp does fit within the state's right to farm law, what does this mean for someone growing hemp in Maryland? The right to farm law would provide a defense to a nuisance claim that could be brought by a neighboring landowner. The hemp grower would be able to prevent claims of nuisance brought by a neighboring landowner as long as the grower is meeting the other requirements in the right to farm law. For example, we have Stacy. Stacy is producing hemp legally, and her neighbor Charlie learns Stacy is growing hemp. If Stacy produces the hemp in line with any potential permits, federal, state, or local laws, and meets the other requirements in the right to farm law, been in operation for at least 1 year, not operating negligently, growing an agricultural product, Stacy should be able to use the right to farm law defense against Charlie's potential nuisance claims. So these farms should fit within the law just as other agricultural operations have in the past. So as we see more growers in the state and other states start looking at industrial hemp as a new commodity to grow, we're going to see potential conflicts. We need to take into account that if there are a nuisance claim, state right to farm laws potentially provide a defense of the nuisance claims. And in the notes, I add some comments on how you can learn how more about Maryland's right to farm law. I'll add in some resources for those in other states who may not be in Maryland, so you can look at your right to farm law and potentially try to start thinking about, would this crop fit, would it not? A lot of it's going to turn upon definitions in the statute and just how the statute has been previously interpreted by the courts. We need to take into account Maryland has few court decisions on the right to farm law. Other states have more court decisions and could more broadly define or restrict how this defense could apply to growers of new commodities, especially those that haven't reached, high adoption rates or be just weird enough that we're not sure if they're ag or not ag. And there are some cases out there. And if you have questions on this, please email me at lgoering@umd.edu, or you can tweet me at aglawpaul with any questions, thoughts you might have on this episode. If you have thoughts on future episodes, please tweet, email, give me thoughts as to areas to cover, questions you have. But until I hear any of those, thank you and enjoy the rest of your day.